Our next panel is Using AI Tools in Significant Decisions, moderated by Professor Margot Kaminski of the University of Colorado Law School, and featuring Stevie DeGroff, First Assistant Attorney General, Technology and Privacy Protection of the Colorado Attorney General's Office, Phil Gordon, Shareholder and Co-Chair of the Privacy and Data Security Practice Group of Laura Middleton, Nicholson Price, Professor of Law at the University of Michigan Law School, Calli Schroeder, Senior Counsel and AI Human Rights Program Lead of the Electronic Privacy Information Center, and Representative Brianna Titone, State Representative of the Colorado General Assembly.
Thank you so much. And we'll get this started, even though we've got folks coming in, because you can see I have the pleasure of moderating the largest panel. We have 6 people for the price of 5, which means I'll do relatively little talking, even though this is a space that I've spent a lot of time in. I think I want to tee up this panel in the context of this larger conference by saying that we're going to be talking about an area that is an example of the adversarial federalism that Tejas mentioned on the prior panel. On the one hand, we have a situation where states are rapidly passing AI-related laws and even more rapidly proposing them. I think the latest number that I saw was that even in the last month, we've got something like 200 to 300 pieces of AI-related legislation being proposed at the state level. It's being proposed in states that are red and states that are blue. Colorado has the privilege of enacting arguably the first of these laws. But if you take a broader perspective on what counts as an AI law, other states, including California, have been passing data privacy laws that move into this space before Colorado was in the crosshairs on these issues. So my substantive introduction is to narrow the focus a little bit on what exactly about AI we're going to be discussing on this panel. We're going to be talking about the use of artificial intelligence in significant decisions. The use of artificial intelligence in significant decisions. So to imagine a few possible fact patterns, you can think of, for example, a company deciding to delegate decisions about whom to fire to an AI system. The arguments are roughly based in efficiency, but also sometimes based in interests in actually avoiding discrimination. If you have a human decision maker making these decisions, they're not going to see all the relevant pieces of data. They're not going to be able to make decisions as quickly to compare across as large data sets and to avoid their own cognitive biases and implicit biases in coming up with whom to fire. That's the optimist version. The pessimist version is that if a company is using an AI system, especially one that was created outside of a particular set of facts and circumstances, then all kinds of existing garbage in the data sets are going to come out in the decisions that it offers to that company. Whether you characterize those garbages as discrimination, or you characterize that garbage as inaccuracy, or you characterize that garbage as inefficiencies, it is something to be thought about when we consider adopting AI for significant decisions. So I've largely seen these conversations take 2 paths, and I think we'll see this come up in our presentations and discussions today. One is to really talk about a fundamental question of whether AI systems in fact work or work well, right? If you're going to delegate something that was done by a human or humans to an AI system, it's helpful to have information about whether those systems in fact work and whether they in fact work better than the humans that you are taking those decisions from. Another way of thinking about these systems, and this comes more from a due process framing, is through the lens of thinking about the autonomy and dignity of the individuals who are subjected to these systems. So is there something, and I pose this as a genuine question, though I have my own thoughts, is there something meaningfully different about having humans in a human organization make decisions about you versus finding out that your number came up in the machine and you know, them's the breaks. So without further ado, I'm going to turn things over for the rest of this conversation to our panelists. We're going to speak in the order in which they're sitting. So Calli from Epic will go first, followed by Representative Titone, followed by Phil Gordon, Nicholson, Professor Nicholson Price, and then Stevie DeGroff. Thank you.
All right, I'll dive in. I will try to keep this extremely succinct because we have a lot of brilliant panelists and I don't want to take up time monologuing. But I'll do a quick intro for my perspective and where I come at this issue. So my name is Calli Schroeder. I am the director of the AI and Human Rights Program at the Electronic Privacy Information Center, or EPIC. We are not the healthcare EPIC or the Fortnite EPIC. Please don't ask me about your Fortnite account, despite the messages on my machine. We really come at this from a privacy and human rights perspective. AI is extremely integrated with both of these things, partly because of how it is built, the training data that these systems are built on and how they figure out their pattern recognition, how you figure out model weights, how you determine which factors are most valuable when you're doing consideration, and also in the way that their outputs are used. So we're looking at both of those things. And I want to start this off by saying that when we're talking about significant decisions, it goes immediately to that lawyer impulse of saying, well, what do we mean by significant? I would argue significant is defined by how it affects an individual. So I really want to focus this on human impacts and on how AI systems impact people. So number one, AI systems are already embedded across multiple industries and in multiple issue areas, probably more than most people expect. We're aware that it's very widespread. I don't know if everyone is aware that AI can be a factor in your hiring, in your promotions, in education, both from the student and the teacher perspective. When you're looking at finance, whether you're going to get approved for a loan or not, when you're looking at criminal sentencing, whether and for how long you are going to spend jail time. And even for things that seem more benign but are very significant when it comes to your pocketbook, like surveillance pricing or automated pricing decision makers. Obviously, surveillance pricing is a little bit of a loaded term, but that is what it is. So, and when we're looking at the distinctions between AI systems and how they make these determinations and humans and how they make them, people that are arguing for a slowdown or for consideration on AI decision making are not saying that humans are flawless decision makers. I don't think any of us believe that that is the case. But one thing that I think is a very clear distinction between AI decision making and human decision making is when a human makes a decision, we know where it is coming from. We can ask that human to explain their thought process, how they weighed different factors, what they looked at, why they came to the conclusion they did. There is some mechanism for appeal and for accountability. And there is not very clear accountability, explainability within AI systems, sometimes even from their own creators. Once many of these advanced AI systems are launched, you can see what they were trained on, you can see what the output is, but even the people that built them can't always explain exactly how point A got to point B there. So when we want to look at how these things affect people in very significant ways, affect their lives, we want to make sure that there is something that is liable for a bad decision. If someone gets sentenced to 10 years in jail for something that clearly does not merit that decision, you want to know, who can I go to appeal this? How can I get my rights met in this way? How can I get information about how this decision was made and why, and how can I push back against it? Those mechanisms really aren't in place in most AI models that exist right now. I would also say that transparency, testing, basic functionality for many of the systems that they're being put in. Also, there's not a great system for testing that. So like there are many general use AI systems, ChatGPT gets mentioned quite a lot, that get plugged into these different industries, but they were not built specifically for this industry. So if you're looking at financial decisions or at education decisions or at hiring decisions, ChatGPT wasn't built specifically for those things, but versions of it are being used in these industries. And because they're not fine-tuned for accurate data, to repeatedly test and audit the systems to make sure that there's not bias or discrimination in the way that they're putting out outputs, it's a real risk that we're seeing across multiple industries. And that's part of why I think there needs to be a lot more accountability there. I'll leave it there, sorry.
Yeah, thanks. Very good to be back here again this year, and a lot has changed since then. I'm Brianna Titone. state representative in Northern Jefferson County. I ran the bill, Senate Bill 24205 and subsequent legislation. We're working on another policy again this year. And the landscape has really changed. And I kind of want to just get a little bit into that before I talk about the legislation. But I think that the real reason why we have this conversation about liability even more than we had is because of all the investments going on into the AI, and now everything is kind of going off the rails. It's a quest for artificial general intelligence. I mean, that's what everybody's trying to shoot for, and maybe we get there with the infrastructure we're putting together with all these data centers, and maybe we don't. Maybe if there's a significant difference in how we achieve AGI and what we're building, and we've invested all this money into it, and we have to build something completely different, the whole funding mechanism is going to fall apart. And the funding of data centers currently is very troubling from a policymaker. There's just reckless junk bonds, borrowing from each other. It's kind of like the bulletin board of a conspiracy theorist trying to connect the dots on where everything is. It's a very fragile house of cards that is hinging on this thing that they're gambling on to win, and we don't even know if we're going to get there. And the whole entire economy is like kind of hinging on this. And the only way that they're able to get their money back is to sell all these AI gizmos and tools that they're putting into everything, partnering with every company on the planet. Put this AI thing in here. AI, it's on everything now. And as a lawmaker, that makes me very nervous because of the data gathering. It's happening at such speeds we never imagined. And the profits that they're making on surveillance of people all the time. Just people are getting spied on by children's toys. And the disinformation, the rogue chatbots, the deep fakes, people don't even know what's happening in the world anymore. That's what worries me a lot. I'm not even going to get into the environmental and utility rate aspects of the data centers as well, but that's a different problem. But all of these things really are to tell you what the motivation is and why this is happening so fast to recoup these investments that have been made, and the political pressure that's being put on the lawmakers with the enormous amounts of hundreds of millions of dollars that are going to go against candidates who go against this community because they're that concerned that if we don't go the way they want to go, their investment's going to be gone. But I believe very strongly that the government was established to help the community, help the people, and we have been doing a lot of product and consumer product safety over the decades. And why should we have any kind of different system with an AI tool? AI tools should have product safety with them, and that was what we were setting out to do with Senate Bill 205. You know, maybe we get there, maybe we won't. I read a recent paper that said that agentic AI mathematically cannot get to a perfect state ever. So there's always going to be some kind of error or hallucination at the end of the day. And we need to make sure that anybody who's using it, whether it's a deployer or a consumer, knows what that risk is. And we shouldn't have blanket exemptions for these companies. And we all know about Section 230 of the Communications Decency Act of 1996, and that had huge blanket protections for a lot of the companies that are now developing a lot of these AI products. And what they dream about is having a similar kind of protection that gives them blanket liability for all the things that they're doing. And I think that is a very, very dangerous road to go down. But what we are working on is having 4 different things that we really want. We want to have disclosure, making sure anybody knows that AI is being used. We want transparency for the user to know what kind of information goes in and out of the ADS, the automatic decision system, so they know what data was being used to make that decision and what kind of information comes out and how that's being used. And if there's a right to cure, you have a credit score, you know what your credit score is being affected by. It tells you that, it gives you some reasons, and if that's wrong, you can challenge it and fix it. That's been on for decades. We need to have a similar kind of system for that. And that's to protect the consumers and to protect the deployers. The problem is that everything's being pushed on these deployers to do all of these things, and it's overpromising. And now deployers are really starting to come around and saying that these investments are not really going anywhere. And the thing that we've been talking about even last year when we were here was regulations are stifling innovation. We're not going to be able to innovate anymore. And, you know, it'll be the end of everything. Well, I disagree with that. I think that regulation is actually going to help the industry, because if you have a product that you can trust, you can sell more of it. Ford didn't sell a lot of Pintos when they started blowing up. And that's kind of what we're seeing now. It's not quite as dramatic, but that's kind of what we're seeing. We're seeing everybody adopting AI, and now we're saying, oh, well, there's too much risk here. So if we actually we take some of that risk out, and we actually get these companies to think a little bit more about how these systems work, what the limitations are, communicating that to the deployers so they know they can deploy that better. The consumer has more trust in it. The deployer has more trust in it. And they can sell more AI products that actually work better. But you have to have the right to cure if you're a consumer for the data. And then we have to have liability. I agree completely with that. Liability is the key, because if there's no liability, there's no chance of getting any AI developer to stop putting out unproven systems that are going to inevitably hurt consumers and deployers. And deployers, all the companies using these AI systems, don't want to have these liabilities. This is fundamental, and we have to get to this point of having some liability. Otherwise, we're going to be on a very, very dangerous road. And we can talk a little bit more about that afterwards.
All right. So, hi everyone. So my law firm is a global firm that represents only management and employment law issues. So my role at the firm right now is advising a lot of global clients about the intersection between AI regulation and data protection law, and how they should manage that risk and comply. I thought it'd be useful first just do a very quick overview of what laws actually are out there currently regulating the use of AI for employment decisions. Because when you think about a significant decision, what decision could be, or what clearly is among the most consequential and significant decisions, is decisions about whether or not someone's going to be hired, be promoted, or be fired, disciplined. So one would think that with all of the laws that, or I should say all the legislative activity that Margot mentioned at the start, that there would be an enormous amount of regulation in the employment space, but it's actually pretty limited. So in the US, first, we have civil rights laws. Every state has a civil rights law. The federal government has a civil rights law. They've been around for a long time. And those laws apply to the use of AI, even if they are not AI specific. But once you get past those laws, there are only a few jurisdictions in the US that actually have an AI-specific law on employment. So we have California is attacking this issue on two fronts. One, in the employment space, the employment law now specifically, or employment discrimination law, specifically addresses the use of automated decision systems. And the Department of Fair Employment and Housing has issued regulations implementing the statute. And then separately, you have the California Privacy Protection Agency has published rules on automated decision-making technology and risk assessments, which also apply in the employment context. Next, you have Colorado. Our law still hasn't gone into effect. Most of you probably know the effective date was pushed off until June 30th of this year. It will be interesting to see whether or not there's change. I think there's a good high likelihood that the law will change. between now and June 30th, given Governor Polis's expression of concern and other legislators' expression of concern about the law. Next is Illinois. Illinois just has a straight anti-discrimination law that prohibits algorithmic bias, also has a notice requirement. New Jersey just published final regulations applying its disparate impact rules to the use of artificial intelligence in employment decision-making. So it's just related to these kind of disparate impact claims. So if you apply a facially neutral rule, but it has a discriminatory impact and there's not a legitimate business justification for that impact, then there is an unlawful disparate impact. So that's New Jersey. Texas prohibits intentional discrimination using an AI tool. So that's right now the scope of employment-related /AI laws and in the US. Outside the US, you have GDPR, which prohibits significant decisions without any human intervention. And GDPR's rule has been followed in many countries across the globe. And the EU AI Act, which has not yet gone into effect, goes into effect August 2026, or I say hasn't gone into effect yet for high-risk decision-making. It's scheduled to go into effect August 2nd, but that date might be pushed off. So right now, for a global corporation, when they're looking at what are their compliance obligations, it's a relatively small universe. Now, what do these laws require? And it's interesting, they basically break down into two buckets. So you have the kind of the civil rights laws, and those laws focus on algorithmic discrimination. Some of them also have a data retention or a record retention rule, or have a notice rule, but those are definitely not the focus of the law. The laws are really about algorithmic bias. And then you have, and that's New Jersey, Illinois, Texas. And then you have California's ADMT regulations, risk assessment regulations, EU AI Act, GDPR, and its progeny. And those laws, which are grounded in data protection, interestingly, have far more protections for the individual, for the applicant, for the employee, including a right of notice, right to opt out, or to request human intervention, appeal a decision made by AI, right to access information that was used to make the specific decision as opposed to a generalized notice about how an employer uses AI across the broad spectrum of applicants and employees. So it is interesting that the greatest protections for individuals tend to come from data privacy laws as opposed to employment laws. And then tying in with our topic today, compliance with these laws can be a real challenge for employers. There's a lot of variation across jurisdictions, laws, regulations. Two relevant examples are what is a significant decision. So for example, in New York City law, it is focused on screening candidates and screening employees for promotion, and that's it. Whereas the Illinois law is basically all material terms and conditions of employment. So there is definitely variations in these laws in terms of the types of employment decisions that are subject to regulation. And the other important variation is the degree of human involvement, which triggers the obligation to comply with the law. So some of the laws, some of the regulations apply if an employer uses AI, which is a pretty low standard. Then there's facilitating. Then there is having a material impact or material influence or being the basis of. And then you go to California's ADMT regulations, and they apply only if the AI replaces or substantially replaces human decision making. So there are a lot of different thresholds. And just to tie this up quickly from a practical perspective, so I'm kind of on the other side from the regulator, right? I'm talking to the deployer, and the deployers are struggling. I'd say a lot of my clients that are multi-jurisdictional, they are actually carving out the jurisdictions that I mentioned early on, and they will just not use AI tools there because they're concerned, it's too complicated. They want to get it right. Number two, my general sense is the people I work with, they don't want to discriminate. But for deployers, it is very hard to analyze these AI tools for bias. And so they are often turning to the vendors, and the vendors will beg off. They'll say, well, this tool is not intended to replace human involvement, human decision making. We always expect humans to be involved. This is just an aid or assistant. So these laws don't really apply to us, and we're not going to conduct the assessment for you. So it's a real challenge for deployers / employers right now. And then, of course, when the employers are global and they have to deal with all of the data protection laws outside the US, in addition to the US requirements, it becomes a real thicket trying to use these AI tools.
Hi, I'm so excited to be here. And I have a confession. I am an AI optimist. I know, it's shocking. But I work in the space of like health and medicine. And a lot of this work actually flows from work that I've done with Margot, Professor Kaminski. And when I hear my colleagues talk about, AI is going to break the world, I'm like, yes, totally. But my little world is already mostly broken. And so I'm really excited about the possibility of AI to make things better. So healthcare, I realize that there's like a legal definition of significant decisions for AI, and I don't think it fits particularly well in healthcare, nor do I hear anybody ever talk about it. So I'm just going to say healthcare is full of significant decisions when you're treating or identifying illnesses, when you're making diagnoses, when you're identifying prognoses, when you're reading radiology scans, trying to figure out, is somebody sick or not? How do we treat them? What do we do with it? Huge number of significant decisions. There's also stuff about like insurance coverage and say resource allocation. I'm not going to touch on those right now. I'm going to focus on the clinical side, but I'm happy to chat about those later. So all of these decisions are happening against a background that expertise in healthcare is expensive and it's scarce. And it's especially scarce for folks with fewer resources, folks in rural regions, poorer folks. Like, it can be really hard to access lots of forms of healthcare expertise. So against that backdrop, the question is, well, what does AI do and how does it fit into this picture? And I think there are many ways that AI can transform the experience of healthcare, but I'm going to touch on 4. So we can think about AI just directly empowering patients. To be clear, often misempowering patients, but providing patients with lots of information. When you talk about people asking ChatGPT, what do I do with these symptoms? How do I treat myself? What do I tell my doctor? Sometimes that's great. Here's information. Here are the questions to ask. Great. Sometimes it's, take a septuple dose of Tylenol. That's less great. But we got empowering patients, potentially really exciting. These are, by the way, ordered in order of how exciting I find them, so I'm just gonna get more excited. The second one is extending the capacity of doctors to do the things that they're already doing, or other clinicians. Like if you say, hey, here's a radiologist, and they normally do they can read X number of scans per hour. Now we have an AI system that's highlighting contours and identifying areas of concern and triaging, really there's nothing going on here, and now I can do 2X in an hour. Or 2X in an hour. And that's great, right? That's just increasing capacity. Well, that's great if it works. But potentially it's great. Potentially it's increasing capacity. The third is pushing frontiers. This is AI letting us do things in the medical sphere that no human physician can do. Like incredibly cool stuff. Like you can look at an AI can analyze an image of a retina and identify things like heart risk, or can look at a mammogram and identify a few pixels that are a little bit off that actually really predicts the likelihood of developing breast cancer in a year and a half at a level that just no radiologist in the world can identify now. Incredibly exciting. And then the one that I'm frankly most excited about is democratizing expertise, which is just to say there are things that can be done in medicine now, but the people that do them are specialists or otherwise highly trained, and there just aren't that many of them to go around. And if AI can make those capacities available to clinicians who don't have that training, that can wildly increase the amount of care that's available to folks that don't get that care right now, right? When we think about places where there is, one ophthalmologist for every 50,000 people, and there are places like that. If you have a system that can take a picture of a retina and identify diabetic retinopathy and say, oh man, you are at risk, you need to go see a specialist because otherwise you're gonna lose your vision in a couple of years, that's amazing. Okay, so I'm not done. I'm not just booster. The question is how do we do this? How do we make sure it works? And this is where I draw on the stuff with Margot, because I think a super common intervention is let's make sure we have human oversight. Let's make sure there's a human in the loop. Let's have somebody in there to make sure that the AI is doing a good job because we want to make sure it works for that particular instance, for that particular person. And so I'm going to go back to those four. The first situation, when you have AI that's providing information to patients, oh man, do they not have any clue at all whether or not that is good information. That is we can work on trying to fix tools with literacy to say, how do you check it with other stuff? But that is a real challenge. Doctors already, of course, are seeing this when patients come in. They've been seeing this for a long time with the internet. WebMD has diagnosed my symptoms. I think I have cancer and also lupus. Well, ChatGPT will do the same thing. The second idea of extending doctors. We might say, hey, you're just asking me to do twice as many things. I'm just overseeing the AI. It's just helping me do my job better, but I'm still in control of it. Great vision, totally awesome vision. AMA loves this vision, calls AI augmented intelligence because it's just augmenting the physician. Turns out, unfortunately, clinicians are really bad at noticing when AI makes mistakes. Just empirically, they're really bad at catching errors, as are most of us. There's a lot of automation bias, and over time, you get skill fade. So people just get worse at actually observing that. When we think about pushing frontiers, again, amazing, do stuff nobody can do before. The question is, how do you have any clue if it's right? If there's literally no one in the world that you can ask, is this right? How do you know that it is right? Handy thing about health, if you wait long enough, it becomes obvious whether something was right. Not always, but often. And then the last thing, if we're talking about democratizing expertise, letting people do things they otherwise couldn't do, if you're asking for them to be a human in the loop and check and make sure that it's right, man, have we gone in a circle. Because it turns out the expertise that you were asking them to use to show that it's right is the exact expertise that they don't have, and that's the whole point. And so, super excited. Really worried about the default way that we try to look at this and the absolute super common regulatory suggestion of let's have a human make sure this is right. What do? Systemic solutions to make sure things work better in the first place. Design system, really the actual answer, and I don't have a full answer, is design systems so that you're not relying on the fact that there's a human there that you can slap the blame on and said you should have caught that. I'll stop there.
Nicholson, I don't know if you're watching this season of The Pit, but there's a whole plot about human gut versus AI in the emergency room. I think you would really enjoy it.
I'm going to. Thank you.
So hi, everyone. My name is Stevie DeGroff. I'm the first Assistant Attorney General in the Colorado Department of Law. My unit works on technology and privacy protection. So I think fitting that I'm here today. And I always have to say when I'm on these panels that everything I'm saying today, I'm speaking about in my personal capacity. And these are not the views of the Attorney General's office. So, although based on experience. So I just want to kick things off today by talking specifically about the automated decision-making laws and regulations that we already have in Colorado. Fun fact, our automated decision-making regulations came out before California's, although they don't apply in the employment context. But I do think that this is really helpful to go through, in part because the rulemaking process we went through really did consider robust feedback from industry, from consumers, from consumer advocates. I remember being on calls with individual people in Colorado giving thoughts on this, and it did actually restore my faith in democracy. And so I think that there's a lot that we can learn from where we landed on our regulations to potentially apply in thinking more broadly about automated decision-making when it happens outside of the context that's covered by our law. So in Colorado, you have the right to opt out of profiling and furtherance of decisions that result in the provision or denial of financial or lending services, housing, insurance, education enrollment or opportunity, criminal justice, employment opportunities, healthcare services, or access to essential goods and services. And I think that list covers what many of us would consider consequential decisions. Now, there's a lot of carve-outs in the applicability of the law, such that like the employer-employee relationship, for example, isn't technically covered, so employment opportunities then becomes limited. But again, I think the framework here can be really helpful when thinking about the application of automated decision-making in these kinds of consequential decisions, even if it's not technically covered by the current law. What is profiling? And that's the reason we're talking about automated decisions. It's automated processing of personal data to evaluate, analyze, or predict personal aspects concerning an identified or identifiable individual's economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. So I think a lot of the words I just said in both of those definitions hit on a lot of the reasons that people are afraid of automated decision-making being used in these consequential decisions, because those are the exact kinds of things, getting to Margot's first point about human dignity, that we are deeply concerned about being abused. And I think one of the reasons why you see a lot of enhanced protections in privacy laws that contain, and again, not just Colorado now, I think there's probably 15 of the 19 states that have privacy laws, have some sort of automated decision-making regulation or statutory requirement around being able to opt out, is because the concern fundamentally about privacy laws is giving consumers autonomy and control over their data to help prevent abuses of the data. And automated decision-making could be potentially an abuse of that data, just as much as it could be a way to make our lives better. So some of the core tenets of the regulations I want to flag, because they tie into what I think are some of the principles to help us think through this problem. So one is consumer agency, right? The law itself says that you have the right to opt out of it. It also gives you the right to correct your data, to delete your data. That data directly impacts the ability of the decision of the system to make a decision about you, right? If the data is incorrect, you should be able to correct it so that the decision ultimately is based on true data. That's a pretty standard principle, I think, of data privacy that applies in this context. I also think this is really fundamental to think about something that, Brett was talking about this earlier, is that we're kind of constantly being opted into all kinds of AI systems, in part for training data. And so if we're really, really being thoughtful about the use of our data from a privacy standpoint and how it is used by AI systems, participation in the AI system is kind of core to that. The use of your data then trains the system. And so they do go hand in hand in that way. The regulations require transparency around what data of yours was used, plain language explanations of the profiling and how it's part of the decision, the benefits and consequences of the decision so that consumers can weigh if they want to allow this system to be used, if they want to opt in or opt out. And then information on if and how the system has been evaluated for bias. Doesn't say that you have to do it, but if you've done it, you have to give the results, and it might be telling to a consumer to know that you haven't checked it for bias in the disclosures. There's in the regulations, we had a lot of conversations in the rulemaking around what type of automated decision this should apply to. So there's an attempt, I believe, that threaded the needle as best we could to balance the risk when you go from solely automated decision, it's truly just you're a number in a system and no person is ever involved, to what is called human-involved automated processing. That's probably sounds similar to like the augmented that you're talking about in hospitals, where it is a tool among many tools that imperfect humans use to try to be a little better when they're making a decision. And so some of the obligations change depending on what type of automated decision is in there in recognition of the risk that exists. There's also data protection assessment requirements that get when you're doing profiling to try to get at, are you as a company considering the risks and trying to mitigate it and documenting that before you roll it out? And again, I think a lot of those things are core to privacy law. They make a lot of sense when you're thinking about automated decision-making as well, right? We heard, transparency, just what is happening and when is it happening and what data is being used at a baseline. Your ability to correct that information, I think, is really, really critical in both of these contexts. And then, balancing the risk, I think, is that's just something that I will say for us when we were thinking about rulemaking, what is the right amount of friction to mitigate harm while still giving consumers agency and access to a potentially beneficial tool? And that's a hard line to walk. And I think that's part of what makes this particular conversation so complicated, is an understanding that there are very real risks there alongside the benefits. But, to your kind of first question, I think, Margot, is like, what do we owe other humans to be able to make that choice for themselves? And when can that practically happen? When maybe do they not get to make the choice, but they at least need information so that if something does go wrong, they knew that they were subject to it in the first place to ask the right follow-up questions, right? So there's different ways you can land on this, but knowing that it's happening, I think, at a minimum is really important. And I will stop there so we can get into some questions.
Great. I'm sure we're going to have a lot of questions from the audience. I'm going to kick us off with a few to start discussion. I'm also going to give just a quick summary of some of the things that we've heard. So my first question is whether we should have one AI law, regulation, liability scheme, whatever you want to call it, to rule them all, or do we try to think about this in a much more site-specific sense? So, one set of rules or regulations for the healthcare context, one set for the employment context, one set for the education context. And this is a much longer standing question that folks familiar with data privacy are going to be very familiar with too. The European Union, I know that we had a comment earlier today that comparative law is not helpful, but sometimes it is. The European Union has long taken an omnibus approach to data privacy or data protection. I know we had a question earlier about the GDPR and whether it came too late, but actually they've had data privacy law or data protection law since the 1970s in different member states, and the Data Protection Directive of the 1990s. So there's a lot of stuff there pre-GDPR, but they take an omnibus approach, like data protection principles apply no matter where you're using personal data. The United States, by contrast, has taken a sector-by-sector approach, sometimes doing more, arguably, than the European Union has in practice, but leaving a lot of gaps and rooms for regulatory arbitrage. So that's the backdrop for this question. I promised a little bit of a summary. I'm a real toolkit person. I really like to create sort of tables that say what's on the table for us to talk about in terms of what tools we can use. So for those not familiar here, here are two buckets and then sets of tools. So we can take an approach that looks like due process that says when you make a significant decision solely using AI or using AI to augment human decision making, that's another question. We owe an obligation to individuals to give them some kind of process rights. So that can range from we give you notice that a decision has happened to we give you access to your data, we have an ability to correct your data, an ability to opt out of that decision, an ability to ask for a human to be involved in the decision, or an ability to appeal the decision. So that's in the due process bucket. If you go into the other bucket, which I think Nicholson mentioned, you are talking about systemic approaches or design-based approaches. And that's more things like, and you might weep from boredom here, but this is the stuff that really interests me, things like impact assessments, data protection assessments, quality assurance, pilot testing, benchmarking, red teaming, all the things that you would do with any product to try to figure out, is this working? Is it breaking? For whom is it working? Whom is it hurting? So that's the backdrop for this, knowing that those are your toolkits. What do my panelists think about whether we have one law that establishes baselines anywhere this is happening versus sector-specific laws?
I'll start, and then I just won't talk anymore for the rest of the panel. No. So I think that I have two thoughts about this. I think that there's certain interventions that are applicable across the board. And I think it's some of the things that you've heard multiple times from all of us today, right? Explainability, accountability, transparency. Those are the kinds of things that make sense, not only honestly in this context, but just for good governance across the board. But then I do think that there are contexts where what would need to happen, for example, in healthcare to mitigate risk is probably different than potentially in education. And that probably, if we're like kind of looking at the divide that you just laid out of due process versus structural changes, to me, it seems like some of the structural changes might need to be slightly more sector specific, while some of the due process concerns could potentially make more sense across the board, across various AI applications.
And I'll jump in there. I think it is a yes and approach if I take the actor's approach, because to Stevie's point, there are basic things that we should have, and that should apply to everything. And that's what we're trying to do this session, is to put a fundamental foundational law in place for those kinds of parameters. We can build on that with specific sectors afterwards. We have to, because everything's changing all the time and the uses and the use cases are changing all the time. So we have to adapt to that. But I think fundamentally those basic tenets we have to put into place now, just to sort of put the brakes on how everything's moving. And I think that's really the critical thing we can do right now.
All right, so second question, this one's much more straightforward. It's about one of the specific tools that's used in the due process bucket. Should people get to choose whether an AI makes these decisions, or can they request a human?
I come at this again from like a privacy human rights perspective. Yes, you should get to choose whether a system is making decisions about you versus a person. But beyond that, I would also say, when we're talking about things like how we're structuring systems and rights that we're giving to people, it also has to come back to a fundamental question of who is it that's bearing the burden here? And in a lot of cases, even when we're talking about empowering people with individual rights, the right to correct information, the right to information, in many cases, that is giving them homework. And that means that on top of your regular job, on top of your regular life, you also have to be parsing through all of these explanations of different technologies that you did not sign up for and did not ask to be part of. And so you have an additional burden to operate your life and your information and the consequences of these decisions. And I think that that is a fundamentally skewed framework when you're not the one that's benefiting in many of the cases, or at least you're not the primary beneficiary. The primary beneficiary of AI use are AI companies and AI deployers. They're the ones that are getting monetary benefit or expediency benefit or efficiency benefit there. So I would make a semi-radical push to say that these systems should be opt-in rather than opt-out, and that this should all be a clear framework shift where AI companies are the ones that have to go through the process of saying, do we have the legal right to use all of this training data that we're using to build our systems? Do we have licensing rights on all of that information? Do we have permission to operate within the spaces that our systems are operating? I think we have to fundamentally shift. They're the ones that are benefiting. They're the ones that should consider that. And people absolutely should have rights over their data, should have rights to a human intercessor in these cases. But that shouldn't be the starting point of how you protect yourself. The starting point should come from the rules around AI companies.
Go.
All right.
Go for it.
Debate is good. Let's do this.
So one thing that's interesting about this debate, general rules versus kind of specific rules, are the edge cases, and there are a lot of them, and the question becomes, how many edge cases do you have that then make the general rule no longer practical? So in the employment context, one place where my clients are using AI kind of by negative inference to make fully automated decisions is the recruitment process. I mean, we have businesses that are receiving thousands or tens of thousands of applications for jobs. It's just not feasible for these companies to review every single application. And the other thing that is interesting is arguably if the AI is done right, I mean, maybe the AI would actually be less likely to discriminate than a human. For example, what's this person in my fraternity? Well, I mean, that's a guy looking for another guy, and likely the guy's fraternity had a certain demographic makeup that may make it more likely that the applicants in that fraternity look like the reviewer. So the number one, you always have to keep in mind that the AI sometimes can solve problems, and then number two, with these edge cases, like recruitment, inevitably only the top 10, 20, 30 candidates will proceed through the hiring process. So there's no question there is decision-making rejection without human intervention. And interestingly, the GDPR and the California ADMT regulations actually allow for that type of decision-making. They require post hoc to give the individual the right to human intervention or appeal, but there's not a right to opt out up front, because there's no way that a large corporation interviewing tens of thousands of people, or I say receiving tens of thousands of applications for a specific position, can review them all.
So I find myself in response to both your first and second questions, Margot, wondering, like a little bit of wondering, like, do I belong up here? Am I playing the same game that the rest of you are playing, or talking about the same issues? Because it's like, oh, these questions have totally different answers in health. We should definitely have a different system. Yeah. And then I wonder, like, but maybe yes, maybe I am in fact asking some of the questions just from a very different direction. So the thing that comes to mind in your second question is, like, what do we do about decisions where the decision would not be made were it not for the AI? And this, I think, is getting at what you're talking about, Phil. Like, so I think about this in the context, right, obviously, of increasing access to care. When the question is like, oh, who is going to do your eye exam? It's either AI or it's nobody, because there's no ophthalmologist within 100 miles or 500 miles. Like, that's a real situation. I don't know what it means to say you have to be able to opt out of that, or you have to be able to say, well, I want a human to make the decision. Because if you say right now, like, I want an ophthalmologist to see me, and nobody says yes, like, you can't force anybody to see you. That's just not how care works. And if the question is, okay, well, here are 10,000 applications, and we're just like, unless you meet certain standards, the alternative is like, we'll review the ones from an Ivy League school and just toss all the rest. And like, those are decisions that just simply would not get made. They would not get analyzed were it not for AI being in the picture. Like, I don't know how we think about that and say, you have a right for a human decision maker for those type of decisions. And I guess I don't know if that's a common fact pattern or a weird one that shows up all the time for me. And now I hear in the employment context. And so I guess I want to ask, like, can I do that? Can I ask my co-panelists? Is this a pattern that, like, is this a weird pattern or a pattern we should worry about a lot? Because I often see a right to a human decision, right? It's right there in the law. Like, what fraction of time do we think that that's actually a meaningful right that could actually be exercised?
So this is partially an answer to your question, but I think it gets it. One of the things that I think about I will say, like, not the downside, but one of the consequences of a lot of this coming from the privacy context is we're thinking about consumer data privacy, and we're thinking about private companies and their obligations to us as consumers. And that relationship is a different relationship than you might have with, often you should have, I would hope, than with a healthcare provider. And, in thinking about consequential decisions, a lot of some of the most consequential decisions that are made about us are made by government entities. So our expectation for the right to have a human be a part of that decision are going to be very different when we're thinking about government benefits coming to us, right? That my very first work in any of this space was when I was still in law school, working on a project for the California judicial system on their use of AI in bail decisions and in bail reform. All right, that's just a very different context to think about having a human be a part of the decision than in my commercial relationship with the business. And so I don't know if that helps you, helps the thesis that you had, but I do think that the context and the relationship at play really does change when and how a right to human intervention, I think, makes sense.
All right, I got one more, and then we're going to open up to questions from all of you. So be ready, students. So this one's a big one, because you hear a lot at least I heard a lot in the conversations around the Colorado AI Act, this idea that we already have enough in the existing legal arsenal that we don't need to have new AI-specific laws. So the question is, are existing laws in these industries around things like product safety, consumer protection, data privacy, discrimination, are those enough to address the risks that we're talking about here? Or are there additional things that are missing that are AI decision-making specific?
I would say that the speed and scale shift within AI, a lot of the issues that we have are not necessarily novel. Like you have product safety issues in tons of products. You have civil rights issues in across the board. You have like health equity and privacy issues and all of these other issues in many, many cases. The problem we see with AI is the scale of it, the volume of information that goes into it, the inferences that can be drawn, and the speed of it, like how fast it's developing, how fast it's embedding itself in other industries, and how fast we're seeing problems pop up from that speed and scale. I think that we do have a lot of laws on the books that could address many of the existing problems. However, the AI industry has been extremely good, I guess, at arguing that AI is so novel and so unique that like the new laws can't possibly apply, or they don't really understand the context, or lawmakers or law enforcers don't really understand how AI plays into this system. That has been shockingly effective in a lot of cases. Like we're seeing that product safety or consumer protection laws are not being enforced in the same way against AI harms as they are against many other industries and companies. So I would say our existing laws could work if they were being enforced properly. I don't, from my perspective, see that they are. And I do think that because AI is so cross-cutting and it's so multi-industry, and there are unique considerations across multiple industries, that there may need to be some sort of structure where you have like a threshold for basic fitness and safety that an AI product has to reach, and then there's sectoral add-ons to that that address specific harms. But again, I defer to a lot of the experts here.
Well, I will say that we understand a lot about this topic even more than we did when we wrote the first bill, and we tried to make another stab at it in the special session in 2025. And that one we were calling the AI Sunshine Act. If you want to see that one, you go look at the engrossed version of the bill, not the final bill, because the final bill was just an extension. But the engrossed version was this framework that was using existing law to have these discrimination and product safety be the foundation of where the results come from if there's an issue. It simplified it a lot more. And I think that was the 205 became a little bit convoluted and put a lot of the onus on more of the deployers and the developers. And that whole issue really kind of got out of hand. So we were trying to simplify a lot of that. And I think that's really what it comes down to. And fundamentally, if 205 goes into effect or 205 gets completely taken off the books, it doesn't matter, because the laws of the state of Colorado still apply to discrimination and those other parameters. So they can still be, the deployer will still be sued for those violations if someone raises them, even if the AI makes that decision. So the risk really is still on the deployer and only the deployer, and the developer gets off scot-free. And this is why I have a big problem with this, because of how I started out saying that they're all just making all this money back of this huge investment, and they don't really care who gets hurt in the process. And that's fundamentally wrong. And there should be some liability on these products that are being tested out on people to try to recoup a lot of their investments. So the liability is there no matter what. We're trying to make the liability more on the responsible party. And what we would prefer is a joint and several liability, where if the deployer is not using the product properly, the deployer has more responsibility. If the developer tells the deployer how to do it and the deployer follows everything, then the developer is more at fault because they didn't make a product that actually did what it said it was supposed to do. So we'll let the courts decide who's really at fault, and that's really the fair way to do it. And that's that's how we should be moving forward. We don't want the deployers to say we don't want to use AI, because that's what's going to happen. But if we make better AI products, we can have a better outcome.
So I think there's a lot that can be done under current law, but I think there are definitely some gaps, and I want to highlight two. The first is there's certainly room for liability to help enforce safety standards, but I think AI is a particularly problematic case for liability, particularly in the tort context, because these things are going to be really opaque and probabilistic a lot of the time, and it makes identifying an AI-driven harm particularly difficult and demonstrating causation particularly difficult. So I don't have a lot of faith in our tort system. I have less faith in our tort system in the context of AI. I'll also point out in the context of discrimination and bias, there's a wonderful piece by Daniel Schwartz and Anya Prince from, 4 years ago now, about proxy discrimination in the age of AI, where they point out that essentially, like, AI is a really, really superb tool for finding things that will in fact discriminate, and yet almost by definition avoiding the possibility of disparate impact litigation if you're in a field where disparate impact litigation still exists. And so I think there's a lot of benefit to saying, hey, here are ways that we're trying to be proactive about bias and discrimination, rather than kind of relying on existing theories.
Yeah, I would just say allocation of liability is a key issue. I think one problem with relying on the court system, it just takes way too long. I mean, right now, my clients are sitting there, they're trying to figure out, if we use this tool, what's our exposure, particularly for algorithmic discrimination? Yeah, we're just using the tool. We can't figure out what's in this black box. Are we going to have to hold the bag if the tool ends up with discriminatory outputs? So I think getting that issue resolved, at least in the employment context, through regulation or by statute, would be extremely helpful for deployers to understand the risk right up front. But as I mentioned at the start, there still are a lot of laws that apply in the employment context that effectively are regulating AI. And it's interesting because the place where there's the most risk today, where I've starting to see successful lawsuits of plaintiffs having interesting ideas, is not so much in using anti-discrimination law. But for example, there's just a case out of the Northern District of Illinois where Ring Central, one of the defendants in the case, was using AI to transcribe, and the claim was under the Federal Wiretap Act. There's another company that's recently been sued that generates scores on applicants based on all the information they submit in the recruitment process. That company has been sued for violating the Fair Credit Reporting Act. There are AI tools that use voice recognition software or other types of biometric information as inputs, and those companies have been sued under Illinois' Biometric Information Privacy Act. So it is interesting that the plaintiff's bar has been very creative in using current law, and they're not waiting around. They are not waiting around to bring cases.
I'm going to add something that isn't about a gap in the law, but is my never-ending crusade for public interest technologists. I really do think that one of the things that has made it difficult to apply laws that are on the books to this new technology is a lack of technical understanding to be able to investigate what is happening in the AI systems. And that's going to be the case with or without a new AI specific law. And so, I think I totally agree. Like, the plaintiff's bar has been wildly creative and in very impressive ways. And oftentimes there's experts that are part of that investigative process. And I just will say, from the government side, like, we in Colorado have hired full-time technologists. I know more and more states are starting to do that. I think it's the kind of expertise. So if any of you have any engineer friends that want to come work in the government, find me and I'll find them somewhere to work, because I do think that that's the kind of deep understanding that's going to be needed to enforce whatever laws on the books, whether it's one that exists or a new one. And to be quite frank, is going to be needed to write really thoughtful regulation that works in this space.
Thank you. We have time for questions, starting with the Phil Weiser rule. I need a student first. Yeah, got a student.
Hi there, Professor Kaminski, everybody.
Hi, Adam.
a colleague of mine and I just drove to and from Oklahoma City with an AI-powered Tesla. And we only had to take the wheel once. So it was 1,200 miles with one intervention. The intervention was a little scary. It was, car tried to back up on a frontage road, but nevertheless, it's powerful. And that car is a NHTSA level 2 car at the moment, even though it functions like a NHTSA level 5. I think it's safe to say Tesla's trying to avoid liability. That's in an area where the regulations are pretty clear. There's 6 tiers, there's graphics. You can say, oh, you're not holding the wheel, that's at least level 3. Disparate impact, by contrast, is utterly unclear. It is at best a judge-made standard that varies by circuit. I wonder if the quest to apply a clear justice standard to an emerging powerful technology is realistic, given that we haven't established one in law yet.
Is that ended a question mark?
Question mark.
Panelists, I think I would, that's an excellent question. Thank you, Adam. Adam took my AI law class, but that's not where he got his ability to ask great questions. So to repeat to the panelists, I understand the question as being, some types of law are incredibly clear and draw bright line rules, and other kinds of law create standards that vary not just in some individual judge's interpretation of them, but across jurisdictions. So which of these types works better when you're trying to talk about a new developing technology?
I'm just a geologist.
I think there's one that's much more tempting, which is like everyone likes bright line rules better. They're very clear and it's very easy to know what the answer is. And wherever it's possible to apply them, great. But the problem with emerging technology is that part of the reason we default so much to standards or to bracket kind of laws is because we don't know what all of the harms are yet. We don't know all the directions it'll go. And so if you're trying to regulate a technology that is moving so much faster than the regulatory process can, it typically makes more sense to make kind of the more broad and general laws as opposed to the bright lines, because we just don't know how we can draw bright lines in the development stage that are going to actually capture things. And in the regulatory space, once you pass a law in a specific area, it's very hard to get the political will to pass an update to that law, because everyone will just say, well, we already have that covered.
I agree with everything you just said, and I will also add in regulatory sandboxes. I was just talking with folks at the Utah Office of AI Policy, where they're like, hey, we have healthcare companies that come in and say the law here is very gray. We don't know what to do. We would like to enable nurses to be able to do this thing that they're not currently allowed to do under law. Actually, that's a little bright black. It's pretty clear. There are other situations where they're gray. They're like, can we have permission to do this thing for 2 years while we watch it under your watchful eye via contract? And they have the authority to say, sure. Doesn't always have to be either or.
Yeah, in fact, in general, it's usually not either or. Yes, back.
I'm Molly. I'm an undergrad, and I'm curious, where do you think well-intentioned educators are most likely to accidentally violate student privacy when using AI, like high school students or like elementary students?
Do we have any education privacy experts on the line? None of this is legal advice. So the question was, where are well-intentioned educators most likely to end up violating student privacy? So there's a legal answer to that, and then there is a good practices version of that. Anybody want to take us?
Sounds like you have both answers.
Yeah. I'm not a FERPA expert, but generally, a lot of student privacy is up to decisions made by schools. And so as a policy matter, a lot of schools are going to make the first adoption decisions on these technologies. One of the waves of legislation that's sort of most prominent in these 300 AI bills that I referenced earlier are children's privacy related laws. And so there's a There are a couple of different types of pushes. There are, which I guess shows that our current regime is not working all that well, or at least people internalize it as not working so well. One push is to empower parents to make more decisions, but the downside of that is that sometimes parents' interests and students' or children's interests are not perfectly aligned. Shocked me as a parent. The other direction to go is to think about, and here I'll point to Brett over there, to think about design and trying to regulate technologies to better protect children by design, and how the technologies are designed, not just in terms of privacy, but also potentially in terms of addiction. So I think the answer is the laws are coming fast and furious, and our current regime maybe doesn't do as much as you think it does. All right, I think we have time for one more question. Oh my gosh. I've got this gentleman not in the green, but right behind you in the jacket who's been waiting very patiently. So there.
So Henning Titone, in some areas, facial recognition in particular, NIST set up a test bed where they could test, for example, bias against skin colors and age and what have you. And presumably, and I'm not a lawyer, you could make an argument that if a law enforcement agency was using a technique that has shown to be inferior and ended up arresting lots of people that shouldn't have been, that they were negligent because there was a known better technology. So one of the questions that I have for areas like bail and employment that are inherently, as was mentioned, probabilistic, as in there is no right decision. You don't know how the candidate is going to turn out that you're hiring, or whether the person you grant bail is going to reoffend or not, or the person you don't grant bail would have reoffended in that. But the question that I have is, are there areas, and medical seems like the easiest, but there might be others, where there is a cause of action because you used a tool that was not evaluated by a third party, such as NIST, or was known to be inferior to other tools that exist based on the predictive capability? And I could imagine in an environment such as education admission for selective universities, where you can indeed predict which factors lead to a measurable successful outcome, GPA, graduation, whatever. In other areas, it's probably much harder to do that. So I wonder if there's in some areas a duty of care, if you want, or a duty of you have to use the best available tool, as opposed to just whatever you got, your salesperson sold you, and you don't have any obligation to look what happened to it.
Excellent question. So the question is, when you have admitting that there are some areas where we don't have verifiability, right? You can't tell whether an answer was actually correct or incorrect because the AI is involved in self-fulfilling prophecies, and you don't really know whether the person you chose not to hire was going to be a good or bad employee. You just know things about the person you did choose to hire. So given that there are other spaces like facial recognition where you can more objectively verify is the output the person or not the person, in those kinds of spaces, are there duties of care? Could you imagine creating a duty of care to either test your technologies in advance or take certified of some kind technologies that we know actually work better? Nicholson, I think this one's partially for you.
Yeah, so you think so. You think so in medicine. It turns out we're actually really bad at doing comparative stuff in medicine. Especially in FDA, it's kind of, does it work above placebo, or like, does it work generally? Is it fairly safe and effective? But past that, we often don't know what's better than something else, which is weird. One of the neat things about AI, frankly, in this space is the possibility to learn what's better than something else, which is like, maybe we would actually be able to theoretically enforce this theoretical duty, but I will tell you that in practice, it is the tort duty of care is quite conservative, and it takes a while to show that, oh yeah, there really was something better that you really should have done. You can do it, and there is the duty, but it's harder to enforce than you might think.
Maybe we have to rely on creative litigators. Okay, so I am going to ask you to join me in thanking this panel 1 second. And ask also that you stay where you are and do nothing. because after this, we're going to have the incredibly invigorating debate about whether chatbots should be banned. All right, please join me in thanking my